Hi, this is Duane Duggan, RE/MAX Boulder video podcast. Today we have Gina Weinberger with us, who is an attorney here affiliated with RE/MAX Boulder. She's going to be talking about what 5 estate planning documents every adult should have. Now you might ask, why is a real estate company bringing this up? As realtors, we have a unique opportunity to visit with our sellers and buyers about estate planning, at least send them in the right direction. Obviously, we're not attorneys, but we find that a majority of people that we work with don't even have a will. They don't have any of these things prepared. So it's a great opportunity for us to push them in the right direction to get this stuff taken care of. So Gina, let's start off with who is the person that should have these documents lined up?
Well, your clients are like a lot of folks. They don't have an estate plan. And every adult, 18 years or older, should have some basic estate planning in place. So to answer your question, everyone, if they're over 18.
Okay, so 18, something happens. The parents are no longer in charge then, so
That's right.
They need to have some sort of directions on what to do if the ultimately bad thing happens, right?
That's right.
Okay,
That's right.
So what are those 5 essential documents that you should have?
So every adult should have a will, of course, a financial power of attorney, a healthcare power of attorney, a directive to physicians, which is sometimes called a living will,
Okay.
and then a HIPAA authorization.
Okay, so let's go through them one at a time. Start out with I'll call it the simplest thing, but because I think most everybody knows you should have a will.
That's right.
But let's cover the will first.
Yeah, so the will, that's that document that explains what happens to your estate if and when you die. And it also names what we call a personal representative. Some states we call it an executor, to usher your estate through probate. So your will says, I want my Uncle Fred to be my personal representative to usher my estate through probate. And then Uncle Fred is directed to distribute your assets according to whatever you've outlined in your will.
Okay, and I think it'd be interesting to talk about what would happen if you don't have one of these. So if you didn't have a will, what happens?
So if you didn't have a will, then you fall under the state's what are called intestacy rules. And when you die intestate, it just means you died without a will. And so we look to our statute, Colorado Probate Code, and it explains who takes if you haven't executed a will. And for the most part, it gets a little wonky, especially with blended families. But for the most part, if you're married, your spouse takes. If you're not married, your parents take. And then it gets more nuanced than that. But
Okay.
there are default rules that would control if you don't have a will.
Okay, and next on your list was the financial power of attorney.
The financial power of attorney, I think, is one of the most important documents, especially when you're talking about an 18-year-old. I mean, an 18-year-old should, of course, have a will, but they might not have a lot of stuff.
Right.
But that financial power of attorney authorizes another individual to manage your financial affairs on your behalf. So when you're a kid, obviously your parents do this role for you, but when you become an adult, there's no one who has that implicit authority to manage your financial life, not even a spouse. So if you don't have a document like that, you could be, your loved ones really could be in a world of pain if you become incapacitated.
So that's probably one of the biggest missing links, because I know a lot of people I talk to, they don't think of wills for their 18, 19-year-old college student child. So
That's right.
it's still important to do it though, and
Absolutely.
financial power of attorney.
Yeah.
Okay, what happens if there is no financial power of attorney?
So if there's no financial power of attorney and someone becomes incapacitated, then there's no way to manage their affairs short of going to the court for a court approval. So for example, say you have a married couple and you're about to sell their house and they own the property as joint tenants. And say the husband has a stroke and loses the capacity to contract. If there's no financial power of attorney, now the wife, say she needs to sell the house, say they're in a financial position where they have to, they're not going to be able to sell that house unless they go to court and get a conservatorship. So you can really avoid some of these tragic situations by having at least the basic estate planning documents in place.
Okay, and let's go talk about healthcare power of attorney.
Yeah, so it sounds a lot like financial.
But
So it's a power of attorney that authorizes someone else to make your health care or medical decisions for you. Again, this is something that you assume a spouse has this implicit authority to do that for you, but they don't. So if you want your spouse to be able to make those healthcare decisions for you, then you need to explicitly give them that authorization and a healthcare power of attorney.
Okay, and what would happen if they didn't have a healthcare power of attorney?
And if you don't, and you have an emergency and you're in the hospital, the doctor comes out, is looking for an agent under healthcare power of attorney, and if there is not an agent, then the doctor has to gather up what we call interested persons. So every interested party that they can find, friends, family, pretty much those folks waiting in the emergency room.
Right.
And say, this group of people, you pick a proxy, and that proxy is whoever that group can come to a consensus about, and it's not necessarily the spouse. There's no priority for the spouse. And if they can't come to that consensus, then you again have to go to court and get a guardian approved by the court. So again, hopefully families get along and that process isn't too tricky, but you can certainly imagine situations in which family members don't agree on a proxy.
Okay, I think it's pretty interesting that in general, all these topics you kind of think in terms of elderly folks needing all this, but you're really bringing it into light that anybody 18 or older should have these things.
Absolutely.
So, okay, let's go to Directive to Physicians, also known as a living will.
Right, and this one a lot of other folks are familiar with. So a Directive to Physicians explains to medical providers your end-of-life wishes, your preferences regarding life support, and without that document, your family can really be in a tricky situation determining how to proceed without any directive from you. This one in particular is important for young folks because if a young person has a coma, for example, the younger you are, the more likely you are to survive in that condition indefinitely. So all those right-to-life cases, they almost always involve folks in their 20s, 30s, and 40s.
Right, because it makes it tougher decisions. So. Right,
and their bodies can hang on longer in a coma or a persistent vegetative state.
Okay, what about the infamous word HIPAA?
Yeah, so a HIPAA, under federal law, medical providers are restricted on who they can give medical information to. So most individuals at some point in their life have signed a HIPAA release because you're asked every single time you go to the doctors, it seems. But for those folks who may not have signed a HIPAA before, we always just throw one into any estate plan and they can name people that they want to have access to their medical records. So if something should happen, at least there's a HIPAA authorization out there authorizing their medical providers to release that information.
Well, that's a pretty comprehensive checklist. I think with the estate laws having changed a lot over the last 20 years, and I'm sure changes are going to be in the future, how often should somebody come in and visit with an attorney to update this list of documents? I
recommend every 3 to 5 years to at least pull it out, look at it again, make sure it still makes sense, make sure the individuals you've named are
still alive.
Are still alive. I was going to say still people you trust. But yeah. And maybe you don't need to change it every 3 to 5 years, but at least you should be pulling it out and taking a look at it 5 years. And if you are a higher net worth individual, then you need very specific attention because that estate tax thing wiggles around a lot, especially with the new administration. So what we talked about today was just for the very basic estate planning documents.
Okay, and maybe that'll be another follow-up with you as far as how it changes as the amount of wealth goes up. That'd be interesting. So, Gina, if somebody wants to get a hold of you to talk to you further about this, how do they get a hold of you?
Sure, they can call me 720-588-9830, or they can find me online at www.GinaWeinbergerLaw.com.
Gina, thanks for being here today. Appreciate your input. Duane Duggan, RE/MAX Boulder Video Podcast, signing off.